Good afternoon and good morning to those in the other time zones. Welcome to this event about whistleblowing, focused on South Africa today. My name is Andreas Stragard. I'm with Primerio, a law firm across the African continent, and I will be moderating the event. With me are, you see a panel of four experts on the topic of whistleblowing, from various walks of life and from various elements of the whistleblowing world, including lawyers, an actual whistleblower himself, academicians, as well as activists and legislators. So without much further ado, I think I want to welcome the audience. Thank you for participating. I want to thank our co-sponsors, Constantine Cannon, Navigate Compliance, and of course, Mail and Guardian, who are hosting this event on their platform today. The topic is particularly timely in light of the potentially proposed and potentially upcoming legislation in various countries, including South Africa, regarding the disclosure and potential compensation of whistleblowers and the protection, most importantly, of whistleblowers after their information has been revealed. And so we figured bringing together this array of speakers would be an interesting event to discuss the potential effects and the pros and cons to incentivize the conduct that we're talking about, i.e. whistleblowing. We have Atholl WIlliams, who was the whistleblower in the Bain case. He is now the CEO of the Institute for, and I have to get that right, the Institute of Social and Corporate Ethics. He's in the UK now. He was formerly resident in South Africa, where he blew the whistle on Bain and Company. And he will be our first speaker. After that, we have Glynis Breytenbach, who is a member of parliament in South Africa. She's the Shadow Minister of Justice. She was formerly with the National Prosecution Authority and was the head of its corporate criminal unit there. We have David Lewis, who's the former director of Corruption Watch, highly regarded activist and social creator of timely institutions, shall we say. And as former director of Corruption Watch, he was highly instrumental in bringing various corrupt activities to light and freeing up the space for his successors to continue that road. He is still active in the sphere, as we can see. And then we have Mary Inman, who is a partner at Constantine Cannon. She has over 24 years, essentially 25 years of experience in the whistleblowing area. And she will speak about her experience in assisting whistleblowers obtaining the protection, the relief, and hopefully then also the success in the courts to the extent required that she's done for the last couple of decades. So without further ado, I would like to hand over the microphone to Atholl WIlliams and let him begin.
Thank you, Andreas. Just to start with, perhaps my involvement as a whistleblower. I was a partner at Bain and Company, the management consulting firm, which is based in Boston in the US, operates globally, and obviously operating in South Africa as well. I joined Bain in 1996 in Boston in the global head office as a consultant. And in fact, was even an intern at Bain the year before. So my story goes back to 1995. I left Bain in 2010 in South Africa. So I worked in the US, in the UK, and in South Africa with Bain. So a long history with the firm, a very proud history with the firm. I think management consulting has got a lot of good value to offer to corporations. And I think management consultants get it wrong, as many professional firms do. But by and large, I see there's a role to play in the economy, and I was proud to have been a partner at Bain. In 2018, it came to light through the Nugent commissions, one of the first judicial commissions where Bain was involved, that Bain had been involved in damaging the South African Revenue Service by colluding with the former president Jacob Zuma to damage SARS, particularly to disable some of its enforcement capabilities. And that's when I got re-engaged with Bain. So Bain came to me asking me to what they described as do the right thing in South Africa, using my expertise in ethics and corporate governance, given my knowledge of South Africa, and of course my history with Bain. And so it seemed to me to be something worthwhile doing, because these were my friends, these were people I've known for many years, these were people, my mentors, who I respected. And so I got involved to try and supposedly do the right thing. But Bain was involved in two big wrongdoings. The one big wrongdoing was its involvement, as it's now known, in state capture in South Africa. The second wrongdoing was and is its cover-up of its involvement in state capture. So I wasn't a witness to the first. I wasn't a witness to what Bain did at SARS and what Bain did at Telkom and what Bain did across South Africa's public institutions, because that's what's at stake here. It's not just what Bain did at the South African Revenue Service. It's what Bain did across South Africa's public institutions, which is where the damage was done. I wasn't first-hand witness to that. I was a first-hand witness to the attempts to cover it up. And from 2018 to 2019, in various ways, they pulled me into that cover-up, and I allowed myself to get caught up in that cover-up. So when I blew the whistle, it was in first instance, blowing the whistle on the attempted cover-up. Because as much as Bain was saying they were fully cooperating with the Nugent Commission and being open and transparent with the South African public, I'd seen enough evidence to suggest that they were hiding witnesses, they were hiding documents, they were actively withholding information from the Nugent Commission. There were cases where even Bain's lawyers, Baker McKenzie, the supposed independent investigators, were advising Bain to withhold information, to not submit a report to the Nugent Commission. So I witnessed all of this. And that's what I blew the whistle on, the cover-up. Now, the fortunate part of my involvement at Bain between 2018 and 2019 was that I got access to a cache of documents, which I could then hand over to authorities to point to the first wrongdoing. So whereas I could speak of personal experience of the cover-up, I now could actually offer hard evidence. My affidavit was 700 pages long of hard evidence to the Zondo Commission to document Bain's involvement in not only the damage to SARS, as I said, but its clandestine meetings with Zuma behind closed doors, after hours, at his residence. These meetings were happening every 6 weeks on average. So I could offer hard evidence for Bain's involvement in the planning of state capture. And this is the important distinction I make, Andreas, between Bain's involvement and all the other companies' involvement in state capture in South Africa. Almost all the other companies were involved in executing parts of state capture. They were overpricing contracts, they were skirting public procurement rules, etc. Only one company, only one firm was Jacob Zuma's consultant of choice. Only one company sat with the planners after hours behind closed doors, and that was Bain and Company. So the involvement was far deeper and far more sinister than just overpricing contracts and looting money. They were masterminding elements of state capture. So I blew the whistle in 2019, and since then I've discovered that in South Africa there's absolutely no protection for whistleblowers, particularly public interest whistleblowers. So for 2.5 years I've had no income. For 2.5 years, I've appealed to our government for support and got absolutely nothing. I've written email after email to the presidency, appealing for support, appealing for physical protection, and I don't even get replies to my emails. I've communicated with big business in South Africa, the big business associations, and they offer no support. So fearful was it for my safety, based on intelligence and warnings I received, that in November of last year, I fled South Africa for my safety. And so I'm in the UK on a temporary visa, so at any point I could be told to leave. And so living this very tenuous life for having exposed what Bain was involved in. And just in closing, the first commission, the Nugent Commission, was very clear that Bain was part of the premeditated offensive, a premeditated offensive against the South African Revenue Service that caused that damage. The second commission, the Zondo Commission, described Bain's role as unlawful, made it very clear that they colluded with those intent on state capture. So there can be no doubt of Bain's role, and there's no doubt that Bain is covering it up. But yet they continue to deny the involvement, and our government and our corporate South Africa continues to ostracize whistleblowers, and that's been my experience of it. Not just neutral disinterest, but it's been active. I'm actively discredited in the media. I'm actively discredited in business circles, in boardrooms.
Thank you, Atholl. And I always think it's fascinating to start these events with, Mary and I have participated in a few of these, to start them with someone who's actually gone through this, him or herself, and lived this. I think it sets the stage quite well for our other three speakers who are assisting or setting the legislative stage for people like you, but who have not necessarily had to live through it themselves. And so I thank you for you sharing this, not only with us, but of course initially back in 2019, for blowing the whistle, as you said. Before I head it over to Glynis, just a really quick question from me to you, out of curiosity. Did you, prior to actually revealing and blowing the whistle, did you seek the assistance of attorneys or others to help you in blowing the whistle, or did you do it all by yourself? Just really quickly.
Well, I didn't know where to turn to. There's no website to turn to. There's no number to turn to. In fact, I did make contact with Dave Lewis's office, but my timing was off, because at the time I was going to meet Dave, the Zondo Commission already contacted me, so I canceled that meeting with Dave. But I did it by myself. I couldn't find lawyers. I mean, I contacted some of the big law firms in South Africa, but when I told them the 39 parties I implicate, not a single one of them would offer me any assistance.
Fascinating. I think that's a fascinating element, and I just wanted to get that out. We'll turn to Glynis Breytenbach now, and her position on, I think, maybe briefly, how your experience went, what happened to you, and more importantly, then after that, looking forward, looking to the future, and what Glynis thinks is the right path forward to A, encourage whistleblowing, B, protect whistleblowers, C, anything else that she believes is relevant from her past prosecutorial experience, to have the right outcome here as a society, not just for individuals, not just for companies, but for justice and really for the society at large. Glynis, the floor is yours.
Thank you very much, and good afternoon. Atholl certainly had a very unpleasant experience, and of course there is no pleasant experience if you're a whistleblower. I'm sorry that he's had that experience, and I want to tell you, Atholl, that if you'd contacted me, I would have helped you. So I'm sorry that you didn't.
Thank you.
So I blew the whistle on the National Prosecuting Authority's refusal to prosecute Richard and Bludi in 2012. For my trouble, I got subjected to a disciplinary hearing, which I won. I later resigned from the NPA and joined the Democratic Alliance as a Member of Parliament. The NPA promptly prosecuted me then for the same charges that they'd party discipline for. Again, I won. Of course, there is no assistance, and of course, people do try and kill you. I must tell you that, Atholl, that you don't have to be worried about your, as you put it, 10 years existence in the UK, because once you've told your story, there's no longer an incentive to kill you. So the UK tried very hard to kill me, but after everything was publicized, they lost their desire to do so, and they haven't tried for some time. As you can see, they're not very good at it. So, having joined the DA as a member of Parliament, I have always been fortunate to be the Shadow Minister of Justice, and so I deal principally with the Justice Department and the courts, and then of course legislation, and also looking at legislation to strengthen the position of whistleblowers. But I have quite strong views on whistleblowers, and they may not necessarily be very popular views. So while I think that whistleblowing should be encouraged and incentivized, I think you have to be very careful about how you incentivize whistleblowing. Otherwise, you're going to get every Dick, Tom, and Harry telling you a very interesting story that got sucked out of their thumb. You're going to spend all of your time on a wild goose chase, and 1 out of 4 is going to lead somewhere, all in the hope of receiving some sort of reward, particularly if it's financial. So that needs to be, I think, very careful looked at. And personally, I'm not in favour of buying information. Many people come to me with the idea that they have the most wondrous information that will lead to the most magnificent prosecution and certain convictions, that they want money for their story. And I've, in my life, never paid for information, and I don't intend to start now. So I'm very wary of financial incentives for whistleblowers. That whistleblowers should have protection, I absolutely agree, and there is insufficient protection for whistleblowers. The Protected Disclosure Act goes some way to assisting whistleblowers, but South Africa has a very, despite popular opinion to the contrary, we don't have a terribly sophisticated witness protection program, and we have no protection program for whistleblowers. Having said that, both of those programs are exorbitantly expensive, and it's really just, it will always be a question of difficulty with resources. We don't have sufficient money to fully resource the police and the prosecution authorities to prosecute the matters that whistleblowers bring to us. There certainly is no money to set up a sophisticated witness protection or whistleblower protection program, and that is always going to be a problem. So, if you're a whistleblower, you're very much reliant on your own resources. So, comfort in the fact that they're not terribly proficient in bumping people off. Whistleblowers have been killed, and it's terribly unfortunate. It's a horrible thing when it happens, but generally speaking, they're not good at it. And there are two kinds of whistleblowers. There's a whistleblower like yourself, who blows the whistle on a company like Bain, and who is not necessarily complicit. And then you get whistleblowers who are complicit. Like, for instance, in the Bosasa matter, Angelo Agrisi likes to refer to himself as a whistleblower. I had many conversations with Mr. Agrisi, and personally, I don't regard him as a whistleblower. He is spilling the beans in the hopes of getting himself either no jail time or less jail. He's not doing it out of the goodness of his heart, nor by an attack of conscience. And so you get whistleblowers who are not complicit, but who find themselves in a position where they, regardless of their personal safety and their personal position and the risks to themselves, do the right thing. And then you get whistleblowers who realize that the writing is on the wall and are trying to negotiate some sort of favorable deal for themselves. And you need to distinguish between those two types of whistleblowers as well. I hold the view that whistleblowers should always The whistleblowers that you're going to incentivize and protect are the whistleblowers who do the right thing and are not necessarily complicit. That's the kind of whistleblowing you want to encourage. The other kind you're always going to have. It's as old as criminal, as the criminal history is. It's as old as the hills. You always have one in a gang or a person who's going to spill the beans to try and negotiate a better deal for themselves. And for them, we don't have to worry about for the purposes of this conversation. So the whistleblowers who are not necessarily complicit, we want to incentivize them to come forward. We want to incentivize them to spill the beans. We want to incentivize them to do the right thing and make it worth their while, but not necessarily with a financial reward. And we need to be able to protect those people. And we need to build a legislative framework that does that. And so we have looked at and we have discussed, and I'm not sure that we'll get to it this year in Parliament, but quite probably next year. We have talked about strengthening the framework of whistleblowing legislation to make it easier for people to come forward, to find a way to offer them some form of protection, or at least to prevent victimization, and incentivize them coming forward. So Atholl, I'm really sorry you had such a very bad experience, but I must tell you that if you had gotten in contact with any one of my colleagues, we would most certainly have made every effort to assist you. And we've assisted many other whistleblowers. I'm quite sure that we would have been able to assist you. And if we can assist you going forward, please feel free.
Will do. Thanks, Glynis.
Okay.
Thank you, Glynis. Thank you, Glynis, for your excellent points that you raised. And from the perspective of a now legislator in South Africa, former prosecutor, I think you do have a unique ability and unique insight. Now, that said, of course, this would not be a good conference, good webinar, if we didn't have slightly differing views from other members of our panel. And I now present to our audience David Lewis. And he and I spoke yesterday, and I believe he agrees with you largely, Glynis, but I think there are elements perhaps where his position differs, and I'm curious to hear from him now. I just mentioned as one introductory remark, yesterday here in the US, where I'm based in Washington, DC, only a mile from where I'm looking out the window now is the Capitol, and we had the famous State of the Union address by our president, Joe Biden. And the First Lady, Jill Biden, brought a guest, as is customary, to the State of the Union. And our audience and our panel members may know who that was. One of those guests was Frances Haugen, the Facebook whistleblower. So here in the U.S., clearly the status of being a whistleblower in very high-profile cases, perhaps even more broadly announced in the media than Atholl's case with Bain in the Facebook case, was Ms. Haugen, and she was the guest of honor of the president here. So I think that's a nice segue into David Lewis's presentation now regarding in what kind of regard we should hold whistleblowers and what else we can do to incentivize the right type of whistleblowing. Go ahead, David. And if everybody else could mute themselves, please. Thank you.
Thank you, Andreas, and hello, everybody. Just by way of background, I have some interesting experience in whistleblowing in as much as the Corruption Watch model, and I was the founder and director of Corruption Watch for 10 years. The Corruption Watch model is based on whistleblowing. We ask the public, or they, I guess I should be saying now, ask the public to report experiences of whistleblowing to us, and they come in at the rate of about 100, 150 a week. And the vast majority of them, of course, are in the category of what is, I think, sometimes misleadingly referred to as petty corruption. And it's impossible to give, and maybe not necessary to give, protection to all of those who come in and report petty corruption, although occasionally they are severely threatened, like they don't get a house because of the corruption that they're blowing the whistle on, or they get abused by the police, and that's the corruption that they're blowing the whistle on, and it's dangerous. But I guess here we're talking, and particularly in the presence of people like Atholl, about a grand corruption whistleblowing. So that was my one experience. My other experience was as chair of the competition tribunal, where we had where before the tribunal cartels were prosecuted. And the prosecutions and the successful prosecutions absolutely relied on a brand of whistleblowing. And I'm pleased that Glynis has introduced the distinction between what is effectively blowing the whistle and what is plea bargaining. And the whistleblowers who came to who came to the competition authorities were plea bargainers. They were people who had been complicit in this covert conspiracy. And for a reduced sentence or reduced fine, they blew the whistle. And I agree with Glynis. I think these are people who've got to be thought about in very different ways. That having been said, I'm not sure what the procedure would be if Angela Greasy had decided, well, I'm not going to go to in the event of financial incentives being given, I'm not going to go and blow the whistle to the prosecution authorities. I'd rather go and blow the whistle to Corruption Watch, and then see if I can be helped to get the money that is offered to those who are whistleblowers. There might be a difficult legal distinction to draw between those kind of whistleblowers in that event. But let me say something about the incentives. I mean, I tentatively disagree with Glynis about the question of financial incentives. I think they could be valuable. They also could be, and I'm not sure if this is the correct word, moral hazard that starts operating there, where you get people coming to blow the whistle either on people who are just their enemies, or come to blow the whistle in order to get the reward and not provide particularly valuable or even truthful information, and waste a lot of investigative and prosecutorial time as a result of that. But so there are difficulties with financial incentives, but I think it is something worth considering. And I think in the US, the experience of the SEC, the Securities and Exchange Commission, is really the interesting example. After the SEC introduced it, I was told that there were literally queues around the block waiting to blow the whistle. And some whistleblowers have given valuable information and have been rewarded beyond what we would consider to be riches. I mean, people have made millions and millions, or been rewarded with millions and millions of dollars for providing the sort of information that the SEC could use to mete out the punishment that they are able to mete out. But what I do think is the most valuable way both of rewarding and protecting whistleblowers is to make of them seriously high-profile characters. I don't generally agree, although sometimes there is good reason for the whistleblowers to hide their identity. But I generally think they're better protected if they become celebrated members of the community, sort of near untouchables, if you like. And this may sound strange, but I think that if the Atholls of this world, and the others who are well known to South Africans, Cynthia Stimple, Bianca Goodson, if they were, if they had national honors hung around their neck by the president, at a public ceremony, and were treated with the same reverence as our cricket captain is now being treated, and the same celebration as our sports teams are greeted and are revered, then I think they would, enter the realm of those who are pretty much untouchable. You say Atholl is out of the country and he believes he can't come back into the country, probably with good reason. But can you imagine, and don't think that I'm exaggerating here, if he was invited back to the country by the president, who was there at the airport to greet him with a national honor, having been flown first class back to South Africa by the government, and awarded this honor, and there's no doubt in my mind that he deserves it. I think that would be the one great reward, and the other great reward would be to do something to Bain. That's the real reward. I mean, there is nothing, and we've seen it in these corporate hotline things. There is nothing that demoralizes whistleblowers more than after they have taken the risks, provided the information, and nothing gets done. And I'm not exaggerating when I say that, just on the SARS issue alone, although my special brand of hatred is reserved for McKinsey, there is no doubt in my mind that the damage that Bain did to the country as a result of what they did to SARS, it features at the top of my list of state capture damage. There is nothing that cost more in rands and cents and in institutional damage compared to what Bain did. And, they are in South Africa, as far as I know, still doing business, probably still doing business with the state. And I don't know, maybe Glynis knows what, laws license businesses to operate. But if there is such a thing as a license that business have to receive in order to set up business, a company like Bain, and indeed a company like McKinsey, should be denied a license to operate. There's no question in my mind. And so I think those two things are the greatest incentive. Make of whistleblowers the kind of people who are held in the reverence that they deserve, which is in the power of the government and the president to do, and act on the information that they give. Because McKinsey got away with paying their fees back. I think Bain got away with something similar to paying their fees back. I mean, if somebody steals a loaf of bread, they're not told, well, okay, pay for the bread now, and the story is over. They get reported to the police and they often go to jail. What is this business about returning the money that you stole and then you get off the rap that you deserve? And that, in a nutshell, is my feeling about how to reward whistleblowers who are not rewarded in this country. I should say, in conclusion, that the Protected Disclosures Act is about as good as this legislation gets, I'm afraid. I think there is more that can be done. I think, for example, organizations like Corruption Watch and others could be given the status of I'm not sure exactly what you call it, of a protected disclosure being made to them, because, for better or for worse, those kind of organizations are often the kind of organizations that are most trusted by the public, and the same trust is not reserved, I'm afraid, for the NPA or the police, or even, dare I say it, for your member of parliament. And I think that these organizations should be given the status of being able to make protected disclosure to. And there are some other bits and pieces that one can do with the legislation. But there is nothing that is not going to make whistleblowing a hazardous business. And, I always say to people who come to Corruption Watch and say, well, will we be protected? I've had to say to them, well, we can guarantee that we won't reveal your name. But if there is a prosecution that needs to come as a result of your blowing the whistle, there is no way that your identity can be kept secret if you agree to that prosecution. We saw what happened to the Zondo Commission for people who tried to maintain their their anonymity, not successfully. So I don't think that there is much by way of legislation that can deny the fact that the way to appeal to whistleblowers is to appeal to their public spiritedness. And mostly they are public spirited, but there is no way that we can guarantee whistleblowers that life is not going to be unpleasant hereafter, except to say that you will be viewed with the greatest reverence possible, the kind of reverence that is reserved for other heroes like sports people and the like. And so, those are my preliminary thoughts on the subject.
Thank you, David. Thank you, David Lewis. I think we have now covered both Glynis's perspective. We have covered David's perspective regarding the carrot and the stick, if I may summarize that, the carrot of elevating the repute and the sort of honor of whistleblowers like Atholl, as well as really carrying a big stick, and not just offering a carrot, but carrying a big stick of enforcement vis-a-vis the companies, the corporates that the whistle has been blown upon, which was David's second point there. And now I'd like to hand it over to Mary Inman from Constantine Cannon, who may have yet a third vision, and perhaps that involves amending the legislation, perhaps that involves more direct and tangible financial rewards, as David mentioned, as we have in the United States. And I would like to hear Mary's perspective from a practitioner who often represents whistleblowers vis-a-vis the courts, vis-a-vis other regulatory bodies and or prosecutorial entities, what she thinks is an effective path forward to enforce the laws that are already on the books. Not everything needs to be amended, perhaps, but also to protect those who do come forward, i.e. whistleblowers like Atholl. Mary.
Thank you, Andreas. It's great to be here today. So I want to start by addressing the question of, do we need to amend the existing Public Disclosure Act in South Africa? Is that sufficient? I think it's really important to note that that is just a retrospective tool. It's a very important tool. Whistleblowers need protection against retaliation, future blacklisting, all of that. But that is only looking in the rearview mirror. That is one of the things that whistleblowers need, a very important pillar, but I would say that there are three legs on the pillar. What whistleblowers also need is, and this was referenced, I believe, by David earlier, is that they need to be empowered to bring the information forward to regulators who can act on it. And so what the American model has shown, and it's also now the North American model, because Canada and the Ontario Securities Commission has adopted a comparable program. So has their Canada Revenue Agency, has an offshore tax informant program. It's not just rewarding whistleblowers, which is, I think, a really important, providing financial rewards to whistleblowers. It's actually the creation of an office of the whistleblower inside an agency that basically clearly signposts to a whistleblower like Atholl who they should go to and how they should give that information, and to do so safely. And I have to disagree with David here, and to be able to do so confidentially, because not all whistleblowers want to have their identities known and have it be a life-changing event. A lot of whistleblowers should just be able to serve as an essentially confidential informants who are bringing that information to an agency. So one of the things I think is really important to talk about here is this concern that if you incentivize whistleblowers, if you give them financial rewards, that somehow they will bypass internal reporting mechanisms because the carrot is so enticing. My clients don't, and I've been doing this for 25 years, representing whistleblowers who I basically help matchmake. They don't do this for the money. 80% of them, according to the SEC, have tried to report internally first before ever going externally. They don't want to destroy their careers. They're not bringing malicious thing to the regulator as a last resort. So I think that's really important to know. And I think when you think that they're going to be this parade of horribles of all of these malicious, avaricious whistleblowers who are coming, it's just not the case. It's not what we have seen. It's not been borne out in the United States. And part of it is because our legislation says you can't just bring information about petty petty crimes. So for the IRS program, you have to be, if you, in the United States, our taxing authority, if you want to bring information to our Office of the Whistleblower, you have to be able to be reporting tax violations in excess of $2 million. So that way you don't have every ex-wife and every ex-husband inundating you with information that isn't significant. So I think there's ways to address that. To Glynis's point that we don't have the money and the resources. So if we open the doors to create an Office of the Whistleblower, for instance, in the South Africa Competition Commission, how are they going to keep up with the flood of tips? Well, I've told you first how you're going to get rid of ones that they're just not eligible, that are too small, ready to come forward. But the biggest piece is that these whistleblowers want to be able to come forward confidentially. And that's a really, really big piece of this. So I think what's important, and I think what I would recommend is I would encourage South Africa to try in SARS or the Competition Commission to institute one of these programs and see if the sky falls. Because it won't fall. So when we empower whistleblowers to bring the information forward, you will see that it's a force multiplier, and you're going to start getting an enormous amount of tips that actually help you do your jobs. Whistleblowers help supercharge enforcement. So the money that you generate by giving tips that actually help create a roadmap and help create great opportunities for great serious enforcement, that money can go back and to fund the very program. So I would say try it and see what happens.
Thank you, Mary. And apologies to our audience members and also to the other panel members who were very eager to hear Mary's suggestion for the technical difficulties there. I think that's a very interesting point, Mary. Try it and see if the sky falls. The sky won't fall is your prediction. We have a few questions from the audience, and I don't know if our panel members can look to it's in my case on the right side of the screen. I will not read them all into the record, so to speak, but I think some of them have been answered, including one that Mary just touched upon, that this can be financed, if I can summarize this, Mary, because I think you were cutting out a little bit, that some of these rewards, financial rewards that could be envisaged for whistleblowers could be financed by the essentially offending corporations, by the fines that are generated out of the whistleblowing consequences themselves. So they would not be essentially a burden on the taxpayer, if I summarize that correctly, Mary.
Absolutely.
Okay. So let me open up the floor, and to the extent that anyone is not speaking, please do mute your put your button on mute. But I'm sure Atholl has something. Let's start with Atholl, and then I'm sure Glynis would like to respond as well. I'm pretty certain of that. Atholl, you first.
Andreas, just two points quickly. The one to Dave Lewis's comment about embracing whistleblowers. It's just an interesting comment. I've written to the presidency 6 times now, and I don't get any reply. I've met with the South African High Commissioner to the UK in London, and she said to me, there's nothing that government can do. Sort of, it's complicated. So I'll definitely will follow up with Glynis on that. The International Whistleblower Organization, PLAW, actually nominated a bunch of state-captured whistleblowers for national orders last year, and we heard nothing. So I agree with your point and the intent of it. I think our government is making a very clear statement of its response to that. Just a point on rewards. I think we can think about incentives, rewards, or compensation. The state capture whistleblowers I know, and certainly I'm in that position, I'm not looking to get rich or make hundreds of millions for what I've done. I did what I did because I believed it was right for our country. As a citizen of our country, I felt I was compelled, it was my civic duty to do it. All I want is to, at best, be compensated for the income I've lost, for the damages I've suffered. That's it. I gave up my income, I gave up my job, I gave up now my home, and I've suffered medical costs, legal costs. I've suffered many other costs. And at best, that's what I think whistleblowers are looking for. So it doesn't have to be as expensive and as complicated as we make it sometimes. I think the rewards of percentage of what you've recovered can be sit on top of that. The point is, for me right now, saying, Atholl, in 5 years' time, you might get a percentage of what's recovered because of your whistleblowing, actually means absolutely nothing to me. Because right now is when I need help, and it's right now when all whistleblowers need help. And so I think we need to start thinking of whistleblowers as emergency public servants, just like we do with the Army reservist. An Army reservist, when called upon, acts in interest of his country. He leaves his job and family, and when he is injured in public service, we compensate him. And I think that mindset has been absent in our thinking about whistleblowers. I think that could change it.
It's a very interesting analogy. I had not heard that before. Did you come up with the Army reservist analogy, Atholl?
I did, Andreas, because I'm a social philosopher. I mean, that's my academic work. And if you think about it, I can think of 3 examples when a private citizen enters the public sphere. When I do something wrong, when I'm a victim, or when I do something good, right? I do something wrong, I get punished, the public punishes me. When I'm a victim, the public might show sympathy, but offer support. My house burns down or there's a flood. But the third one, we don't know how to deal with that when someone does something good, right? So the Good Samaritan, or the volunteer who does some good. And the best analogy I found in thinking about compensating voluntary people who do good is the Army reservist. Because what's key with the Army reservist is they have normal lives. They're not public servants. They're private citizens. But when called upon, they forego a lot of elements of their life. But as society, we compensate them. We don't reward them with big money. We compensate them for their health, their lost income, and anything that comes up that they'll otherwise lose.
Very, very interesting concept. Sort of maybe a little bit also like jury duty here in the U.S., but yours is probably better given the higher risk that the reservist takes compared to somebody who serves on a jury. You know, the risk of injury or death, etc., and similar to the risk that whistleblowers like you take. Glynis, was I mistaken in believing that you had some responses to the points raised, or I believe you do? Let me turn it over to you.
Sure. Thank you. I do have some responses. My first response is to Mary. I would really like to explore your suggestion of setting up an office in one of the institutions in South Africa. And if you could direct me to a place where I could find more information on that, I'd be very grateful. I would certainly like to give that a try. And then, yeah, I hear Atholl's analogy with a reservist. I don't necessarily share that view, but I get where he's coming from. Something I'm happy to argue over a glass of wine. And I repeat my offer. If Atholl thinks we can assist him in any way, he should please get in touch. I don't necessarily think that David's idea of including institutions like Corruption Watch as institutions that could assist whistleblowers officially is a bad one, and that's certainly something that we could also explore. I think South Africa finds itself in a unique place right now in our development that we should encourage whistleblowing as much as possible and look at encouraging people to come forward. Again, I must stress that I believe people should do the right thing, and you don't neither make a fuss of nor do you reward honesty. It's what's expected of you. But I do get the problems associated with whistleblowing, and it's not that I approach it with a closed mind. I'm very happy to discuss those issues and think about them. And I'll certainly raise them with the Justice Portfolio Committee as well in our discussions, and also try and motivate for such an office to be set up somewhere. Perhaps in SARS would be best, and I could speak to the commissioner about that. Certainly, of all the institutions, they probably are financially the best place to deal with something like that. So,
I think
those are my views, and I would encourage if other people have useful information to please let me have it, so that we can try and develop that. Whistleblowing structures in South Africa do need to be developed. That I certainly agree with. Thanks.
Thank you, Glynis. I think it is a fascinating example that we're witnessing right now, to have an actual active legislator on a panel who can really put things into motion potentially. You know, there's of course no promise of that, but there's at least the potential for that while we're on this webinar, this seminar, that there are ideas being exchanged, and I think this is perhaps one of the more fascinating opportunities to do so. So thank you, Glynis, for taking that in so carefully. Mary, I think, just dropped off again, at least her video feed. So let me ask David Lewis whether he has some points in response. While our time, we have about 7 minutes left.
Yeah, I mean, just to make, maybe the most obvious point, and that is that, the fact that Atholl writes to the presidency 6 times and doesn't get a response. Welcome to South Africa. Welcome to the club. I mean, the fact of the matter is that the lack of attention to whistleblowers is a subset of the lack of attention to corruption, actually. And that's really what we're facing in the country. Once that becomes a truly a national preoccupation, we'll see much quicker responses, and we'll see many of the good ideas that others here have suggested being taken up. But frankly, the will to tackle corruption is very low. I mean, Atholl was blowing the whistle on a group of people, on a company that one would like to think South Africa has no particular investment in. I mean, try blowing the whistle on a senior member of the governing party, or on somebody who has sort of influence and power in the society, and then you may not be alive, as Ms. Diakaram discovered. There's whistleblowing and there's whistleblowing, and if you're trashing some American consultancy, well, you might not get an answer to your letter, but you also might not get killed. If you try blowing the whistle on somebody more powerful in the South African society, the risk increases, and it's a consequence of corruption, at pretty high levels of government and public life that is the real problem here.
I believe that Glynis Breytenbach has the perfect solution for that already. And unfortunately, we have not witnessed your dogs today, Glynis, but during our pre-meet, we saw one of your dogs. So I think having 2 big German Shepherds, Atholl, that may be an instantaneous, if only imperfect solution. Mary, we have you back now. David just made some very, very interesting remarks in response. Would you like to add some to what you've heard Glynis say?
Yeah, so I think important is that, and this is to Glynis, but also to Atholl, is that what financial incentives rewards seek to do is to actually serve as basically a financial safety net for whistleblowers. So I think it's unfair to think of them as bounties, and I think it's also unfair to think, so when whistleblowers speak up in the public interest, they're speaking up on behalf of all of us, but yet they are bearing all the costs. So the whistleblower protection laws like PETA, it's very difficult to, that only protects you as to that one employer who harmed you, not as to all future employers who are going to blacklist you. So what financial rewards seek to do from the government agencies who use it is to give, on the risk reward calculus, to give an incentive to whistleblowers sitting on the fence, wanting to do the right thing, but having to say to their spouse, I'm about to try and do this thing that I think is really important. I want to do it, but I'm the sole breadwinner in my family and I may never work again. So but if you can then say to your spouse, hey, there's actually the prospect of, if the government acts on my information, I get a percentage of it, then it doesn't feel like a fool's errand. People under PETA, and even in the United States where we have very strong protections, in the UK, they don't win an employment tribunal. So you may have these great laws saying I was retaliated against my employer, but the statistics are like 10% of people win. And again, that only protects you as the one employer. So I think it's really important that if you want, and I think all government agencies should want the information from whistleblowers, because it helps them to unlock and provide a roadmap for the fraud. If you want them to come forward, you need to put a financial safety net under them. And in the UK, they call it unemployment insurance. Basically, what rewards are is a one-time payment, a lump sum payment of a career-long loss. If you start to look at it that way, then you're going to get a lot more people coming forward in recognition that they want to do the right thing, but without a safety net, it's very hard to do it. The last thing I want to say is that I think it's really difficult. I don't believe that the US programs are a panacea. They're not. One of the biggest limitations of our reward programs is that we only pay rewards to whistleblowers. We only create offices of the whistleblower for whistleblowers who help expose fraud against the government. We don't have anything similar. We're incredibly hypocritical when it's fraud by the government. So that's where, and I know Cynthia Stimple is listening in today. She has a new nonprofit called Citizens of Conscience. She's trying to talk about the creation of a office of the whistleblower, not just within individual agencies like I'm proposing to Glynis, but actually one that sits in government that protects whistleblowers, both private and public. And that seeks to potentially, one of the things we've been talking about in the UK with their legislation they're considering, is letting some of these financial whistleblowers and the monies that are imposed in fines help fund whistleblowers who are exposing the health services and other government corruption.
Thank you, Mary. And I think it's a very valid point that it's always much easier for government and for whoever else the decision maker may be to reprimand and then incentivize, respectively, third parties rather than themselves, right? Same with the corporate in-house hotline that Atholl was talking about and others. Yes, of course, there is the human resources department or whatever you want to call your HR people. But the question is, do they have your best interest in mind, or do they have the company's best interest in mind? And the answer is fairly clear. It's a rhetorical question. I don't need to answer it here. So same goes for the government in a way. And I think that's a very good point. We are running out of time, and I am instructed by the Mail and Guardian and our other co-sponsors that we should stick to the time. There are several other questions pending. Everybody can access this webinar, this presentation later on as well, and replay it. Our contact information will be displayed on the Mail and Guardian's website and also on our respective individual, LinkedIn and other pages. We're all semi-public citizens, some of us much more so than others. I think I need to cut it off, unfortunately, even though I would like to go over, but unless there are any really crucial closing remarks, in which case, please raise your hand. I would like to thank everyone, Glynis, Mary, Atholl, and David Lewis, for their participation in this. I think it was really fascinating. I hope the audience has enjoyed it as much as I have. I've certainly learned something. I think the fact that Glynis is taking notes and maybe bringing some ideas to her colleagues in the South African Parliament is a fascinating thing that you don't get very often during these webinars, that there's actual potential action occurring and taking place as a result. I applaud that, and let's hope for the best. And this will not be the last seminar, by the way, on this topic. We plan to have more. This should be a series, not a one-off. And again, thank you all for taking the time out, and thanks to the audience. With that, I conclude the session.